Everybody. My name is Harvey Ryder. I'm with the Jewish Community Relations Council, and I want to welcome you to the most recent in our series of brown bag lunch programs. A couple of things logistic-wise I wanted to go over before we talk about our program. I'd ask you, if you join, to place yourself on mute, and if you have questions, please enter them in the chat box. And we'll take them up. We should have plenty of time for questions today. And depending on the number of people who have questions, we may unmute you as well if you want to ask a follow-up of our speaker. So this is the most recent series of brown bag programs that we run, sponsored by the Jewish Community Relations Council of Greater Washington, Tzedek, DC, the American Association of Jewish Lawyers and Jurists, the Jewish Federation of Greater Washington. And I want to thank all of our sponsors for this and other programs. We'll have another program in July with a speaker who will talk about what will have then been the Supreme Court's decision on the anti-abortion law in Mississippi. So I think we'll have a pretty good turnout for that. And we'll give you notification about other upcoming programs as well. So again, if you haven't already, please put yourself on mute. And I also would suggest that you place your program in not in gallery mode, but rather in speaker mode. I think you'll find that easier to watch. We also have a live transcription, and this program will be recorded. I want to welcome our guest speaker, Robert Corn-Revere. I won't take a long time with a speaker bio. Some of his background is on the calendar notice of this program, and I really recommend his Wikipedia page to get a full sense of his remarkable career in First Amendment law. So I'll limit the introduction to this. Robert Corn-Revere is a partner in the DC office of Davis Wright Tremaine. He's a multi-year recipient of the Best Lawyers Lawyer of the Year Award for First Amendment law. Among his many notable cases was his successful representation of CBS in the Super Bowl wardrobe malfunction case, and his successful petition to then Governor Pataki of New York for a posthumous pardon for comedian Lenny Bruce's obscenity conviction. He's a past president of the First Amendment Lawyers Association and was appointed this year to the Advisory Council for the American Library Association Freedom to Read Foundation. I mentioned this last point because of the JCRC's deep involvement in local school systems, working on issues such as strengthening Holocaust education, combating school-based anti-Semitism and other forms of hatred, and ensuring our schools are safe and nurturing for all students. And this leads us to be especially concerned with issues of censorship. Recent initiatives in Virginia and elsewhere to limit discourse on divisive or controversial topics could undermine efforts to increase understanding of anti-Semitism throughout world history and a range of issues related to Israel's history and current challenges in the world in general. Before I turn the program over to Robert, I want to give a plug for his wonderful book on the history of censorship in the United States. It really is a remarkable piece of work. The book is called The Mind of the Censor and the Eye of the Beholder. It's a powerful reminder of the dangers of censorship from the right and the left that have marked our history. So with that, I'm going to turn the program over to Robert and welcome him here. Thanks for joining us.
Thank you so much. I really appreciate being asked and hope that folks will find what I have to talk about interesting. I think you mentioned the current controversies over both school curriculum and books in schools are a flashpoint that I'm going to explore in some detail. First, just a couple of notes about my background in that regard. One is just one small correction. I have been a member of the Freedom to Read Foundation board, but this year was named to the Advisory Council for FIRE, the Foundation for Individual Rights in Education, which focuses on free speech issues at the university level, and just was proud to be asked to join that advisory board. Anyway, I have practiced law in Washington, D.C. for 39 years, almost going on 39 years, and most of that time focused on First Amendment issues. And in that time, handled a variety of First Amendment issues involving education. I've been honored to represent twice Mary Beth Tinker in amicus briefs in various cases. As you may recall, Mary Beth was the plaintiff in the landmark case in 1969, where the Supreme Court upheld student rights. The famous line from the Supreme Court opinion is that neither students nor teachers shed their constitutional rights at the schoolhouse gate. And in that case, upheld her right and her brother, along with her brother, to wear black armbands to school to protest the war in Vietnam. And then Foundation for Individual Rights in Education, as I just mentioned, I've represented them and students that they have sponsored in over a dozen cases in challenging various speech restrictions at the university level. This work has extended to cases involving library censorship, and I handled the first case involving mandatory library filters in a public library in my home county, Loudoun County, and the case was Mainstream Loudoun versus Loudoun County Board of Trustees. So the area is sort of erupting at the present time, but it's not one that is unfamiliar to me. And as Harvey mentioned, and thank you for the plug, by the way, I do explore those historic connections to censorship in the mind of the censor and the eye of the beholder. Now, right now, people, when they hear what I do for a living, they'll say, oh, it must be a great time to be a First Amendment lawyer. And to a certain extent, that's true. We're seeing an upsurge in a range of First Amendment issues, including issues involving the classroom as sort of a byproduct of the culture war that we've been going through these past number of years. Polarization has been increasing in American society, particularly over the last 6 to 10 years, picking up during the Trump years, and it's touched on so many issues involving immigration, race, voting rights, abortion, obviously, gay rights, and transgender issues. Now, some of these have even been propelled and been made, perhaps made more polarized by gains in other First Amendment areas. One of the issues that I have worked on in a number of cases involves the right of citizens to photograph police when they're doing their work in public spaces. And we all recall going back to the early 90s, the Rodney King tape that was so shocking, showing police abuse. That was a watershed moment. But oddly enough, it wasn't until 10 years ago or so that courts began to recognize that there was a First Amendment right to engage in that kind of photography. And so over the past number of years, we've seen, as that right has been established and acknowledged, a number of additionally shocking videos showing various kinds of police abuse, perhaps most famously the murder of George Floyd, which has propelled a number of
access to behavioral health, counseling.
I'm getting an echo. I don't know if that's coming from some kind of feedback. Anyway, those kinds of First Amendment cases have then contributed to the issues that have led to even further polarization in some of the issues that we're seeing involving the schools, sort of a perfect storm where the series of videos showing police abuse, the rise of social media and the ability of things to go viral, divisive politics, and also things like the New York Times publication of the 1619 Project, and that being latched on by various political actors, both on the left and right. And that's focused attention on one area where politicians do have a measure of control, and that's over school curriculum. And so we've seen these battles go from just society in general and the political realm to taking place in schools and in battles over, state policies, over local school board elections, and so on. The actions have included federal executive action, mandated restrictions on school curricula, various book challenges and bans, and even most recently, use of criminal law to target certain books, even books available in bookstores. I mentioned the 1619 Project. That was a watershed moment. The New York Times Magazine in August 2019 published the 1619 Project, and the lead essay by Nicole Hannah-Jones asked readers to imagine that 1619 was the nation's founding rather than 1776. And it suggested that preserving slavery as an institution was a primary motivation for the American Revolution. And you can imagine that raised some consternation among some, and not just conservatives. A group of prominent historians wrote to the New York Times suggesting that the analysis was driven more by ideology than fact. They wrote a rebuttal that was published by the Times, which then had a response. And there was a drive to incorporate the message from the 1619 Project into college and high school curricula. The Times selected the Pulitzer Center, which runs fellowships and grants for journalists and develops curricula based on journalism to produce a companion curriculum. 17 states sought to expand their curriculum on what they called anti-racist history, which would incorporate materials like the 1619 Project. But given the level of polarization, as you might expect, 36 states then adopted efforts to restrict that type of curriculum, as I'll go into some more detail later. Following that, in the summer of 2020, when the murder of George Floyd riveted the nation, it led to protests across the country, institutions responded to this, and some of them promoting more of the anti-racist instruction in curricula, and others responding, going in the opposite direction. Now, again, as I mentioned, this is something that was addressed at pretty much all levels of government. Under then President Trump, the Office of Management and Budget said that the federal tax dollars should not be used to promote this kind of thing. And in September of 2020, Trump gave a speech at a White House history conference where he claimed that the left has warped, distorted, and defiled the American story with deceptions, falsehoods, and lies, identifying certain efforts by name as being especially pernicious, naming specifically the 1619 Project. And he said the crusade against American history is toxic propaganda, ideological poison that, if not removed, will dissolve the civic bonds that tie us together. It will destroy our country. Now, as ironic as it may seem to hear someone like Donald Trump talking about dissolving the civic bonds that unite us, that was his message. And he followed that up a few days later with an executive order that tried to enforce that view through a number of federal measures. For example, it adopted rules that define particular divisive concepts dealing with race and sex in America, such as the argument that the United States is fundamentally a racist country. Now, if you read the list of concepts from the executive order, some of them are pretty unexceptionable. For example, it lists divisive concepts as one or more race is inherently superior to another race or sex. Then goes into things like a divisive concept is that the United States is fundamentally racist or sexist, that an individual by virtue of his or her race or sex is inherently racist, sexist, or oppressive, whether consciously or unconsciously, and it goes on. But anyway, those kinds of divisive concepts were the kinds of things that fed into the debate over and the state actions over what should be included in various curricula. The executive order prohibited the expression of these concepts in any federal training programs, and it directed all federal agencies to compile a list of grants to see if any of those should be canceled as a result of including those concepts. Now, this executive order was rescinded on the first day of the Biden administration, so it's no longer operative. But again, this is part of the ongoing politics of the issue that will affect what we may see in future administrations. This obviously became fodder for politicians. A number of senators introduced bills to prohibit the teaching, including specifically the teaching of the 1619 Project. One of them was introduced in June 2020 by Senator Tom Cotton, would prohibit any federal funds going to any educational institution using the 1619 Project. As I say, there were at least 10 bills of that kind. This naturally led to efforts by the states. And I should say, before I get too far into that, that in our system, the states do have control over what the curriculum is, particularly at the K through 12 levels. It is a function of local school boards, state agencies, and it rarely becomes a matter of constitutional import when states are simply selecting what their curriculum is going to be. And as a consequence, the legal response to these kinds of political decisions is sometimes pretty limited. PEN America, the Center that protects writers and artists, compiled a list in late 2021 of these efforts throughout the states. And it found that 24 state legislatures had introduced 54 bills to restrict teaching in K-12 schools, higher education, or state agencies, and 11 of those had passed by late 2021. 42 of the bills mimicked the Trump executive order and contained prohibited lists of divisive concepts. 48 of the bills applied to teaching in public schools, 21 applied to teaching in public colleges and universities, although there's some overlap in which bills cover what. 11 bills specifically mention the 1619 Project. 9 bills focus on what is called critical race theory, which talks about how institutions reinforce and preserve racial discrimination. 10 of the bills prohibited teachers from compelling belief in what are called divisive concepts, however that may be defined. And 8 bills mandated the, quote, balanced teaching of divisive concepts. So again, pretty much a bad idea whenever state legislators go to prescribing particular lesson plans or curricula, banning particular books, but that's what these were directed toward doing. For example, in Tennessee, a bill prohibited curricular materials that, quote, promote, normalize, support, or address lesbian, gay, bisexual, or transgender issues or lifestyles. And then, of course, very well known, the Florida Parental Rights and Education Bill, which was dubbed the Don't Say Gay Bill, prohibits classroom instruction on sexual orientation or gender identity in grades K-3 or in a manner that is not age appropriate, developmentally appropriate for students in accordance with state standards. Now, if you read the Florida bill, now law, its terms don't seem to be particularly onerous. I mean, if you're for people under 3rd grade, don't talk about these concepts. For people above 3rd grade, talk about them in an age appropriate way. Most of the commentary I've read on it suggests that while the language of the bill may not be so harsh itself, we know what they mean. You know, it's passed by people whose agendas we know. The problem with laws like this is that they're so broadly and ambiguously drafted that they can be employed in a wide-ranging way. And so a teacher may never know, very difficult to know, when they have gone into forbidden territory. It's one of those things that people find they have violated after the fact rather than at the time they're engaging in whatever the instruction is. A lot of these efforts, as I say, most of them have not passed, although the debate over them is ongoing. But they've already led to a number of pernicious effects. The Texas Partisanship Out of Civics Act requires teaching widely debated and currently controversial issues without giving, quote, deference to any one perspective, close quote. Now, this bill was signed into law. It went into effect in September 2021. And you've probably seen reports of this, but it was widely reported where an administrator in Texas was telling teachers, if you have a book on the Holocaust, under this law, you have to have one that is opposing or that has other perspectives. And so again, it gives an example of how ridiculous it can be for some of these measures to try and prescribe particular curricula, and how when they're drafted in this way, they can be very badly interpreted. Florida's Stop Woke Act forbids a one-sided discussion of divisive topics, whatever they mean by one-sided discussion, and whatever may fall into the basket of things that you would give instruction on that is called divisive. But even worse, and this is something that is going to, we'll see where this leads, but it empowers citizen suits. That is, these laws are going to be enforced by essentially angry parents who sue the schools. Now, as a general proposition, I don't think being able to sue schools on behalf of students is necessarily a bad thing. I've sued schools on behalf of students trying to preserve their own First Amendment rights. But where you have political issues that then are used in this way to drive a particular agenda, then I think it's sort of a recipe for chaos in the schools.
I could just ask you a little bit on this question of the Florida law. If I recall, and it might have not have been this one, but there was another related law that also created a private cause of action for employees of companies that had training in anti-bias or other similar programs, if it made them feel uncomfortable or guilty about their race or religion. How constitutionally would that be viewed differently from the ability of the state to regulate the content of courses in a school in a case?
Yeah, I'm not familiar with that particular bill, but it is what you've described is consistent with themes that we have been seeing as these controversies have erupted. So, for example, when the Trump executive order came out, it talked about compiling a list of people or companies that have federal contracts or federal grants to prohibit this kind of, quote, divisive training among the recipients of those grants. Now, as a general matter, the government would be constitutionally barred from prescribing what a private business does in training of its own employees. But if it ties that restriction to federal grant or federal contracts, then it may be on different legal footing. So those are the kinds of things that they have looked at. And the notion of tying it to training programs is something that came directly from the Trump executive order. In Virginia, it was obviously a hotly contested issue during the governor's campaign for governor that Glenn Youngkin made it a centerpiece of his campaign, and even set up an email tip line as governor for parents to send any instances where they feel their fundamental rights are being violated. As you mentioned, the citizen suits notion, that's been incorporated in a number of laws. And some had proposed even putting cameras in classrooms so that people can watch the instruction online, and then it feeds into whether or not there's going to be some sort of citizen action. Some states have even faced some dueling mandates. In New Mexico, for example, the public education department had just put together a curriculum to explore inequality through the history of the United States and its connection to conflict that arises today. And this was quickly followed by Republican legislators proposing a ban on teaching the idea that social problems are created by racist or patriarchal social structures and systems. And so you can imagine what it would be like being a teacher in New Mexico to have the state education department saying one thing with the curriculum mandate, and then that facing possible liability under state law for the same lessons. There have been spillover effects. I'm seeing a comment, and Harvey, I'll let you handle those things, but just to continue on the idea of spillover effects in Florida, for example, in the debate over the Don't Say Gay bill, the Disney company came out in opposition to it, said that the bill should never been proposed and that it would work to see that it be repealed. And the governor responded by adopting in a special legislative session, promoting and proposing and having adopted legislation to remove the special tax district status that Disney had to basically manage its own affairs, simply because he didn't like the opinion that had been expressed by Disney's CEO. That's an example of an action that I think is flatly unconstitutional. There is a First Amendment doctrine known as the doctrine of unconstitutional conditions. You can't condition the exercise of a constitutional right on a state benefit, even if you have no right to that benefit in the first place, and yet to remove that special district status because of the political opinion expressed by a company's CEO, as I say, I think absolutely is a violation of that notion. In addition to all of these actions on curricula, there have been a number of book bans that have been adopted. Now, this is really nothing new in that this has been an ongoing discussion ever since there have been public schools. Parents seek to ban particular books either in the classroom or in school libraries. The American Library Association has for many years kept a tally of the most banned books, and they kind of vary over time to a certain extent, but there's also a certain consistency to the subjects they touch on. For example, anything involving teenagers and sex has always been on the list, but even longtime classics like To Kill a Mockingbird regularly make that list of most banned books. But this has picked up in the last year. PEN America issued an additional report beyond its report on controls on curricular speech. And they found that between July 1st, 2021 and March 31st, 2022, there were book bans in 86 school districts in 26 states that affected 1,145 titles by 874 authors. Now, two things to keep in mind about that. One is when we're talking about book bans in this context, we're talking about bans that may be temporary. If something was banned for even a day, it was included in the PEN America list. And also some of these are very regionally focused. For over 40% occurred in Texas alone. But nonetheless, that is a big increase from previous years. And the subject matter that is covered generally has been changing along with the types of topics that we've seen political activity the most polarized. One of the things that's notable about these book bans is that 96% of them failed to follow the best practices for removing a book from either a library or a curriculum recognized by the American Library Association and the National Coalition Against Censorship. And these criteria do have some legal backing. There is some law in this area. But basically, what these organizations recommend is that whenever there is a challenge to a book, there be a formal written challenge stating particular reasons for removing the book, that the formal complaint go to a review committee made up of librarians, teachers, administrators, and community members, and that they read the challenged books in full, and that those books remain in circulation during the deliberation with a process for appeal afterward. As I say, 96% of the time in these recent book bans, that procedure was not followed. It was followed in only 4% of the cases. And that 41% of these directives came from either state officials or lawmakers, some from complaints for citizens groups. In October 2021, State Representative Max Krause sent a letter with 850 titles to Texas school districts, asking them to investigate or report on which of the titles they had in their libraries or in their school curricula. And what's interesting is that the titles seem to be selected almost at random. So, for example, one of the books listed on his 850 titles was a book called Cynical Theories, which is a critique of critical race theory. But I think he got confused and thought it was something promoting critical race theory. So he simply put it on the list. Some have suggested that the list was put together just doing word searches. And if you found those terms, they were dropped onto the list. Nonetheless, that list did have impact in a number of Texas school districts where they removed a number of the books if they found them as part of their collection. As I say, over 40% of the book bans were in Texas alone. And, a list like that may be part of the reason that's true. And then most famously, in this past January, the McMinn, Tennessee School Board voted to remove the book Mouse by Art Spiegelman at the request of a board member. This badly backfired, as I'll mention later, but these were the kinds of things that once something got some attention, then they would simply put it to a vote without going through the usual procedures that are required for removing books. The focus has also turned to allegations that certain books are either obscene or indecent, which is something of a perennial subject of these kinds of book bans. But this has now been wrapped into the debates over what are currently divisive political and social issues. South Carolina Governor Henry McMaster, for example, sent a letter to the Secretary of Education in November to demand the removal of obscene books from the Fort Mill School District. And he specifically mentioned the book Genderqueer, a memoir by Mara Kababi. The district responded with a permanent ban. So all it took was a letter from the governor. The same thing in Texas, where Texas Governor Greg Abbott directed the Texas Education Agency and the Texas Board of Education to develop statewide standards to prevent the promotion of, quote, pornography and obscene content in Texas schools. Once again, he singled out Genderqueer by Maya Kubabi and The Dream House by Carmen Maria Machado. The ALA reports that Genderqueer was the most challenged title of 2021, along with books like To Kill a Mockingbird that regularly makes it onto their list. Most recently, we've seen, and this is a very recent development, a resort to obscenity law. There's an old 1970s era statute in Virginia that allows a citizen to bring a complaint in the local district court challenging, that in this case, not school libraries, but actually the sale of books on the basis of obscenity, and they can be enjoined from the sale if a magistrate finds probable cause to believe that the titles are obscene. And in the last week or so, Representative Timothy Anderson of Virginia Beach and a Republican candidate for to be state delegate Tommy Altman brought a complaint in Virginia Beach to reach a finding that 2 books are obscene. And once again, we see the title Genderqueer, and then the second book was the Court of Mist and Fury, which is a retelling of fables and myths with more explicit descriptions of sex, gore, and magic. This petition went before a local magistrate, actually a retired magistrate, because they couldn't find a local judge that would handle it. And a finding of probable cause was reached, and these 2 books have been suspended. Now, under this state law, either the publisher or the bookstore can come to court within 21 days to show that that the books are not obscene under the pretty demanding standards for what is constitutionally obscene. And if the court finds that they're not obscene, then the sales are then unimpeded. If they are found to be obscene, then under this law, they could be prohibited from being sold anywhere in the jurisdiction. And so it's a pretty significant matter. And it's something that has not been used, as I say, since like around the 1970s. The TRO that was issued has been modified to apply what is called a harm to minors standard. This is a variation on the law of obscenity that is called harmful to minors or obscene as to minors. It's a sort of a lesser standard that allows matters to be restricted for sale to minors if they're considered to be obscene as to minors, but not adults. And it would be like keeping adult magazines behind blinder racks or back behind the counter in a store. What that would mean is you would have to either have your parents buy the title or some other adult. And again, it won't be until sometime in June when we see what's going to happen with that. I would expect there will be a showing that these books will then have essentially their day in court. Hard to predict how that will come out. I don't know either of the titles, and all I know is the description that I read in the Washington Post when I read about this case. And from the description, I think that it is highly unlikely that either book could be considered obscene under the constitutional standard. It's possible that one of the books, could be the book Genderqueer, could be considered harmful to minors if this description that I read in the Post is characteristic of the whole book. The Post says it includes graphic sexual scenes, including depiction of oral sex and masturbation, as well as a sex toy. And one panel of the story shows a sexual fantasy of the authors in which an apparently teenage youth is about to engage in fellatio with an older bearded man. So on one level, it's understandable that some have gotten very up in arms about this. Whether it meets the legal test is going to be another question, and the one that we'll see probably in the next few weeks.
Before we turn to our next topic, I wanted to just raise a couple of questions that have come up in the chat box about what you talked about so far.
Okay.
One really has to do with your discussion of how few cases where books are removed from schools have involved the best practices approach.
Yeah.
And I'm wondering, to what extent have you also seen people librarians, for example, take preemptive cautions by removing books before they're even challenged? I think there was a story in the Post about something like that.
Yeah, I mean, I can't speak to the general practice, but I've read accounts that suggest librarians do that. Also, librarians also don't share the same mind, although in my experience with the librarians I've worked with, most of them are very ferocious defenders of the First Amendment and understand those rights in a very broad sense. Not all do. Some take a more conservative approach and will do things like remove books based on either concern for political reactions or other reasons. But again, it's hard to generalize.
So there was another question in the chat box, and it has to do with Governor Youngkin's executive order and how that's been applied to, essentially create a tip line for anonymous claims that what teachers are instructing their students are divisive concepts. And I think there was a story in the Post about how the Virginia Board of Education had interpreted his order to say that would mean an end to training on equity and inclusion. And there's a question, and I don't have the person's full name, Lynn, I can't read, the full name doesn't appear on here. I could ask Lynn to go off mute if she has an example of how his executive order has an impact on DEI training. So Lynn, if you want to take yourself off mute.
Yeah, can you hear me, Harvey?
Yes.
Okay, I own a company that does DEI training and sexual harassment training, etc. And we work with a lot of large organizations in the military and federal government, state government. We bid on a project to do DEI training and also gender bias training for Virginia Military Institute in December. They have a new superintendent that replaced the previous one, who is a retired Black general and is very progressive on these issues and wants to fix the racism and sexism that still exists at VMI. So my company bid on it, as did 9 other firms, and we were told in, I think, December that we were going to be awarded the contract. And it's basically to cover all of the diversity, equity, inclusion issues. They are also the only institution in the state that does not protect rape victims if there's any evidence of alcohol involved in the incident. So they have a terrible reputation on women as well. They didn't even allow women until the 90s. Anyway, so after we were told that we were going to be awarded this contract, a company that bid and didn't even make it to the first round decided to file a protest, and that was followed by a lawsuit. The law firm is a conservative law firm in Virginia that is very close to Youngkin's campaign. The name of the firm is Mars and Henry. They filed a lawsuit against VMI and actually included us as a co-defendant. We ended up getting dismissed from the suit because we hadn't yet even been awarded a contract. But that lawsuit is going to tie up VMI's attempt to address these racist issues probably for the rest of this year. And they'll probably prevail. I don't know. But if they do, we'll get a chance to do that work anyway. But the basis of the lawsuit was ridiculous. Its primary, it was filed by somebody that lost, who said that it was arbitrary and capricious that he lost, and he accused us of, conspiring on price and all kinds of BS stuff. But his primary objection is that it violated Governor Youngkin's first executive order to ban diversity training in any public institution. Now, this is an academy, a college level. This isn't K through 12. And they should not have been, it's not a legitimate lawsuit, but it still has stopped VMI from doing this work. And so our intelligence tells us that this is the first of many such lawsuits, especially in states that have a conservative Republican governor in place, that there will be other suits against any organization that gets state money to do DEI training. And I don't know about sexual harassment, sexual assault, perhaps that as well. But I expect to see a lot more of this. So that's what I wanted to talk about. And that was in the Washington Post twice over the last couple of months. And we don't know what's going to happen with the lawsuit, but it's the first of many.
Yeah, well, thank you for bringing that up. I think it's exactly the kind of thing that happens as these issues become part of the polarized political atmosphere. And also when you invite basically citizen suits to enforce these. Now, I can't speak to the law of government contracts. I don't know really anything about that. But again, where you create these issues as political talking points, it opens the door for these kinds of challenges, and can bog down the whole educational process. Now, as I mentioned before, these kinds of things are not new. I mean, we've had these kinds of controversies ever since we've had public education. These are really sort of an outgrowth or a new example of the kinds of things that we have. Public education, you'll recall, was part of the progressive movement in the late 19th and early 20th centuries. And by 1916, around 1916 is when education became compulsory in virtually all the states. This was sort of paired with the anti-child labor movement. It was paired with mandatory vaccinations. Once you were requiring students all to be in the same place, they were required to get vaccinations in most states. And so along with that came the battles over school curriculum. Today, it's about history and DEI issues. In the 1920s, the debate over curriculum was about teaching science and evolution. So by the 1920s, 27 states had considered some, 37 different anti-evolution bills. And Tennessee happened to be one of the states that adopted one. And this led to the Scopes monkey trial in 1925, where a teacher was arrested for teaching evolution in Tennessee schools, even though evolution had been part of the standard textbooks they used in Tennessee for decades. Nonetheless, Tennessee adopted this law in the 20s, it became one of the first, I think first of many, trials of the century. Now, the Scopes trial was notable for a variety of reasons. One was it was the first trial that was publicly broadcast on the radio, and it also featured star power in that you had William Jennings Bryan, three-time presidential candidate, former Secretary of State, volunteering to be the prosecutor and being accepted in that role, and Clarence Darrow, engaged by the ACLU, then a sort of brand new organization, engaged for the defense. And the trial itself was immortalized in the Robert E. Lee and Jerome Lawrence play Inherit the Wind, followed by a movie of the same name. And very famously, during that trial, because they wouldn't allow any scientific testimony, Darrow, in an act of desperation, called William Jennings Bryan to the stand as an expert on the Bible. In that play and in the movie, much of the actual dialogue in the cross-examination of William Jennings Bryan is taken directly from the trial transcripts. So it's a fascinating thing, but that was an example of how these kinds of politically charged issues lead to these kinds of legal confrontations. Now, in the end, John Scopes was convicted under the Tennessee law, although his fine was thrown out by the Tennessee Supreme Court, essentially on a technicality. But the Tennessee Supreme Court upheld the constitutionality of the law. One of the things that does, the other thing that happened is essentially Tennessee received such negative attention, not just in the United States, but worldwide, that it essentially killed the drive toward more anti-evolution legislation in the states, and Tennessee has been living it down ever since. There are a couple of lessons to be drawn from that, and one of them is that in areas of prescribed curriculum, because the state does have quite a bit of power in this area, that the legal solutions are really pretty limited, in that states can decide what they want to teach their students, and it isn't in most cases, a constitutional issue to interfere with that. Now, there are a few exceptions to that. In 1923, the Supreme Court decided the case of Meyer versus Nebraska, which was a state law that had prohibited teaching in any language but English. And a person who was trying to teach children in German was prosecuted because it was part of the fallout from World War I, and anti-foreign legislation was popular, but the Supreme Court did hold that that was a violation of due process. But apart from that, the ability to challenge, particularly a K through 12 curriculum, is really pretty limited. It wasn't until 1968 that the Supreme Court struck down an Arkansas anti-evolution law, but that was done on Establishment Clause grounds. That basically, it was clear in the record that Arkansas had adopted this specifically to reinforce Christian principles as opposed to the evils of evolution. And so it was thrown out on that grounds, not because there was a right found elsewhere in the First Amendment to prohibit that kind of limitation on curriculum. And at that time, sort of as the fallout of Tennessee's great embarrassment over the Scopes trial, only 2 states had anti-evolution bills that were anti-evolution laws that were still on the books. So there was that. And when it comes to school libraries, the most direct Supreme Court precedent was in 1982, and that was sort of on a limited basis. It was a plurality opinion. Only 3 justices signed on to Justice Brennan's opinion that basically said that removing books from a library can't be done for arbitrary reasons. But the court limited its scope, saying 2 things. One is it was not talking about curricular speech, that states could control what they were going to have in their curriculums. And secondly, it was not talking about book acquisition decisions. It was only if there were wholly arbitrary reasons. So for example, a school district could not prohibit any books written by Democrats, or couldn't prohibit any books written by Republicans. But if they went through the kinds of procedures that were recognized in what are now listed as the best practices of the American Library Association and the National Committee Against Censorship, National Coalition Against Censorship, sorry, then that will indicate that it's not being done for arbitrary reasons. But apart from that, there's not a lot of law in this area. Now, fortunately, the other lesson to be drawn from the Scopes trial is that activism and efforts that sort of embarrass the other side can sometimes be the most effective ways to combat this kinds of censorship. So, for example, in the Central York School District in Pennsylvania, that had originally banned some 441 titles in the school district, students and others in the community mounted a responsive campaign that drew unfavorable national attention, and as a result, the school district rescinded its decision. Same thing happened in at least one school district in Texas, where 432 titles were originally removed, and ended up sending all but 11 back to schools after the reaction to that. And I mentioned earlier the ridiculous decision in Tennessee to ban Art Spiegelman's Mouse. The reaction to that was really overwhelming. The book had been out there for 36 years, but after this happened, it went to #1 on the Amazon bestsellers list. Area businesses began to respond to it. So for example, a number of comic stores in the Tennessee area began to give out copies of Mouse to anyone who would request them. And other bookstores started picking up on this theme, some doing a similar giveaway program, some donating proceeds to the American Library Association. And others sort of picked up this theme too. A couple of children's authors, novelist Catherine Applegate ordered 100 copies of the book Walk Two Moons after it was discovered that it had been banned in a school district, and simply told the bookstore, give these out at your discretion. And her husband, also a children's book author, did the same thing with Mouse. So even though the legal options are not as fulsome when it comes to these kinds of curricular and sometimes library decisions, there are ways to push back against these kinds of censorship efforts.
Just to follow up on that, Bob, one of the questions we received from Michael Siegel, and it relates to a theme in your book too, that oftentimes some of the excesses of the censors have resulted in a backlash that turned out way different from what the censors originally intended. So his question is whether we're not going to see significant political or legislative activity to protect diversity of thought in education, and whether you know of any examples, for example, fighting back against limitations on some of the programs.
I think the examples that I just gave are examples of fighting back, but it's the tricky part is finding a way to fight back that is both effective and doesn't contribute to polarization, right? I mean, if you see that, most of our political dialogue has been poisoned by people on the extremes of both sides simply shouting at each other across a chasm, we've got to find a way to re-engage in a dialogue that can find some accommodation for people of all views. This is particularly true in school systems where we are in a shared public school system. Attendance is compulsory unless you are going to an accredited private institution. And the decision about what people are going to be able to read and what the curriculum is going to be are shaped by politics. And it isn't true that both sides are either completely right or completely wrong. I think that, parents who are concerned about a book like Genderqueer, if the description in the Washington Post is accurate, might have some valid concerns. And concerns about the 1619 Project are based not just on political positions, but historians have weighed in on it. And there's a debate to be had. The question is how to have that debate in a civil way that allows people to reach some kind of accommodation.
So there's another question that came in, and it was really, it's described as a tongue-in-cheek response, but it sounds to me like this person may have even read your book. You talked about this, and we talked briefly before the call today about Dr. Wortham, this noted psychiatrist who was a progressive of his era, but who also was grossly upset about violence in comic books. And so the question here is a tongue-in-cheek response. Someone suggested that the Bible might be banned because of violent content. But if I recall from your book, you also talked about the fact that people who were, fighting the bans of comic books because of their violent content in the late 30s and early 40s had given examples of similar content in the Bible.
That's right. That's right. And interestingly enough, I mean, speaking of how times really don't change, and the arguments, oddly enough, don't change that much either. The issues of salacious bits in the Bible and violence in the Bible were arguments made part of arguments over obscenity in the 1870s. They picked up again in debates in the 20th century and again when we were talking about broadcast indecency. These arguments continue and they sort of get adapted to whatever the current issue is. But we see this coming up over and over again. And I list a number of moral panics in the book that take these on, and then the same arguments get plugged in and recycled in various ways. The other thing that happens is that the controversies of yesteryear seem to be silly and quaint when you look back on them, and a lot of things that drove the debates over literature in the 1890s and early part of the 20th century are seen as just quaint by comparison. And yet they were deadly serious at the time. And then finally, the notion that censorship almost always fails. It isn't the solution for what people consider to be the problems. And this is true again on both sides. And in my book, I carefully try to document censorship from both the left and the right in various times in history. And that is, for a variety of reasons, it makes the information more sought after and more attractive. And a great example is what happened with Mouse when one school district in Tennessee banned it, and then that became a news story. It drove it to the top of the charts on Amazon, and local reactions then did as well. Again, this story keeps repeating itself.
Harvey, you're muted.
So there are a number of questions in the chat box, and I know we're running close to the time, but a couple of things I wanted to cover. One was yesterday's ruling in the 11th Circuit blocking a Florida law that barring social media platforms from blocking politicians from access to their platforms. And Governor DeSantis, who was the censor-in-chief, making the response that he was disappointed that the court continues to permit censorship. So I don't know if you've had a chance to look at the court's opinion.
I have, yeah.
If you want to comment on that.
Well, the only thing I'll say, or at least one of the only things I'll say, is that Governor DeSantis is confused. That he doesn't understand the concept of censorship. Censorship is prohibition of restrictions by government, not by private platforms. This is something that has been raised in lawsuits across the country. Texas has a law just like Florida's, although that one's still sort of in a state of flux. But virtually all of the courts that have addressed that issue of whether or not decisions by a private platform of what kind of speech they're going to moderate are private decisions protected by the First Amendment from government. And that when the government tries to intervene in that, then they're the ones violating the First Amendment and not the platforms.
So one thing I noted from your book too is, you say in the long run, a lot, while there are fits and starts, we generally move to a more tolerant society about, what we restrain and what we allow, by way of speech. So question I have is, in some countries, they ban with vibrant, I think you could say vibrant, longstanding democracies, prohibit hate speech.
Yes.
And just like, some countries, don't follow our exclusionary rule in criminal cases, but they have a robust criminal justice system. Do you think it's essential to a vibrant democracy with something like a First Amendment that they allow, and we allow hate speech? You can't incite, but you can say hateful things.
Well, that's right. And the main comparison in that regard is between us and European systems that do allow prohibitions on hate speech. My preference is for the American system because I think that it creates a presumptive protection for speech, and any of the exceptions to that are very limited and very carefully described. And so the presumption, again, is toward protecting speech, even speech that we're going to find to be hateful or what we'll think of as no value. In Europe, it's very different. And they have a protection, the baseline protection for speech, but there are many more exceptions in the European Convention of Human Rights. And so it's sort of like you're protected, maybe. So the exceptions are more widely limited. I think that our system over time has proven to be superior, even though you remember back in the 1970s when the ACLU defended the right of the American Nazi Party to march in Skokie. It was really a real defense of those principles. Over time, I don't think that deviating from that understanding of free speech would make us any better. So for example, if you think of the Unite the Right rally in Charlottesville in 2017, where a young woman was tragically killed, I don't think that has persuaded more people to be white supremacists or more hateful. For example, the week after that demonstration, the white supremacists were outnumbered 800 to 1 when they did a similar rally in Boston, or a fringe religious group like the Westboro Baptist Church that made homophobia sort of a hallmark of its gospel. Allowing people on that fringe to express their ideas in that way, as hateful as it is, hasn't made the United States any less tolerant. It didn't slow down the drive toward marriage equality. And on the other hand, countries that have robust hate speech laws, like France, have, I think, at least, some would argue higher levels of anti-Semitism, where a candidate like Marie Le Pen is a viable presidential candidate. Again, I think generally I would err on the side of protecting speech and not allowing government to be less than neutral when it comes to choosing which speech to protect and which speech not to.
So I'm going to there's one more question from Jed, I think Sorokin, and I think it was prompted by your discussion of that lawsuit in Virginia invoking that 1970s era law that would allow a local magistrate to limit the books that were obscene. So Jed, if you want to take yourself off mute, you can ask the question. Maybe that's the easiest way to do it.
Sure, thank you. So my question was, let's see, yes. I was just wondering if you have optimism that courts will apply past precedent to these types of cases, or do you sort of share my concerns that, as we're seeing with the leaked draft abortion opinion, as with last week's Fifth Circuit recent decision against the constitutionality of administrative law judges with a host of other issues in recent years, Janus versus Ask Me, et cetera. Do you fear that courts and the Supreme Court, et cetera, will choose to create a new obscenity test that books like these might fall foul of, sort of narrowing or otherwise limiting what had, what might have been protected in the past?
Yeah, that's an excellent question. And I continue to be optimistic. I think that the courts, and particularly the Supreme Court, and even this Supreme Court, has been exceptionally protective when it comes to First Amendment issues. It's hard to say that in the wake of the leak of the draft opinion that would overturn Roe versus Wade, but that goes to the issue of substantive due process, analyzing what rights exist that are not specifically enumerated in the Constitution. And there's a lot of academic debate that goes on in that area. And, there's much to be said about this travesty of having a draft opinion leaked and what that means for the court and its perception of legitimacy and so on. When it comes to those rights that are enumerated, and particularly First Amendment rights, the court has been particularly good in holding the line, even against what others would consider to be low value or harsh speech. I expect that will continue. I know the question, speaking of the 11th Circuit decision on social media law, people have speculated what that will mean when it gets to the court. And I think there are certain justices that are less favorable than others when it comes to those kinds of protections. But I still expect that the court will reach the right outcome on cases like that. Oh, and one other point about that, this case in Virginia, which was the genesis of this question, there was a magistrate that did sign off on this temporary restraining order for the books, but they had to go past two judges who I think recused themselves from having to rule on this and find a retired magistrate. I think if you find the right judge in the most backwater court you can find, you're going to be able to get a ruling like that. And that's what happened here. I do not expect that ruling will be affirmed once there's a hearing on a permanent order.
Bob, so I have one last question. It's really combining a couple of questions. You had talked earlier about in the political arena, the best way to, what is the best way to fight back in a civil way, when you're looking at potential censorship. So in the context, for example, of school curricula, where, and I'm offering California as an example, where there was a discussion about the role of different minority groups in California and U.S. history, and where there was a debate about what groups have been excluded or defined as minorities. So what would be your advice on the best way to approach issues like this, where you think a curriculum has been over or under inclusive?
Well, one of the reasons why I generally try and practice in courtrooms and not engage in politics is that I feel much more comfortable making legal arguments based on precedent by a judge who has to write down his reasons. I'm much less comfortable in the political arena where people can make decisions for whatever reason or no reason, and they don't have to be consistent. But for people who are wanting to promote a particular approach to curriculum, whether it's more inclusive or if they have different ideas about what that should be, get out there and make your case. Make your best arguments for what you think should be the right answer, and see if you can persuade a majority of people to agree with you. I don't know what else to say about that.
Well, Bob, I want to really thank you very much for joining us today, and there will be a ton more to cover if we had the time. But I really want to thank you very much, and just remind everybody that this. I think we'll have a recording of this for those of you who weren't able to join us, and people who weren't able to join us and wanted to attend. They'll be able to do that. We'll send out a notice in the next few weeks of our next program. And again, Bob, I want to thank you so much for joining us today on this really timely topic. It wasn't quite as much in the news when you first started writing about it, I think, and in your book, but it sure is now.
Well, thank you so much. It's been a fun discussion. I hope people were interested.